Good afternoon. My name is Megan Hughes. I am a lawyer with the Human Rights Law Centre. We're an NGO based in Australia and also have consultative status accreditation with the UN. The focus on our presentation today is on children who interact with both Australia's criminal law and care and protection systems. The literature refers to these children as crossover children. Judicial systems, both in Australia and around the world, are currently not set up to consider the best interests of children experiencing both welfare concerns and criminal law issues. Further, these systems can be improved in the way they facilitate listening to children's perspectives and giving their views due weight. In Australia, more than half of children under youth justice supervision have also received child protective services in the previous 5 years. While this presentation will focus on Australian children, it is important to note that these trends are also observed in other countries, including the US, Canada, and the UK. Bawadi and Ball, in a recent article in the Children and Youth Services Review, have outlined that children who are in contact with welfare services are more likely to have experienced trauma, mental ill health, substance abuse, and have instability with respect to their healthcare and education. These risk factors have all been linked to criminal behaviour in children and young people. In terms of children's participation, a literature review conducted by Van de Ville, published in the Child and Family Social Work Journal, found that children in out-of-home care generally felt that their views were not necessarily valued or acted upon. The authors explain that children who believed that their views were taken into consideration reported that this made them feel valued, and this was also associated with greater positive outcomes. Children's courts in Australia have two distinct jurisdictions: the criminal jurisdiction, which deals with allegations of infringement of the criminal law by children, and the civil care and protection system, which investigates allegations of abuse and neglect against children. Despite so many of these children interacting with both systems, the separate jurisdictions of the Children's Court are unable to cross over. This means that courts are unable to holistically consider the child and make orders that take into account their best interests, as required by Article 3 of CROC. An example of how this works in practice is that the judicial officer might be prepared to grant a child bail, but because of their alleged criminal offending, welfare services struggle to find a suitable place for the child in foster care. Because they have no safe place to go, the judicial officer denies bail and the child spends time in custody. In this situation, the child is moved back and forth between staff in juvenile detention centres and foster carers. This disrupts their education, healthcare, and other social supports. Article 40, subsection 4 of CROC states that a variety of dispositions, including care, guidance, foster care, education, as well as other alternatives to institutional care, should be available to children accused of crimes. Australia, by not allowing judicial officers to make decisions about care when approaching a child accused of a crime, is in violation of Article 40. Article 40 outlines the rights of children who are accused or convicted of criminal offences. Also, Article 20 outlines the rights of children who are temporarily or permanently deprived of their family environment. There is very limited literature on how these rights interact and how state parties should approach children who've been removed from the care of their parents and also accused of a crime. The Committee on the Rights of the Child is currently considering a draft of General Comment 27 on children's rights to justice and effective remedies. Given the vast number of children, both in Australia and around the world, who experience dual system involvement, we call for guidance from the committee. General Comment number 27, or a further General Comment, could provide guidance on how state parties can uphold children's rights under both Articles 20 and 40. At a domestic level, we are also advocating for Australia and other state parties to fuse the civil and criminal jurisdictions of children's courts so that welfare matters can be considered at the same time as criminal matters. We propose that a new General Comment, as well as domestic responses, should consider three factors. Number 1, Article 3, crossover children in every matter, the child's best interest must be the paramount consideration. Number 2, Article 24, children experiencing dual system involvement are more likely than their peers to be in need of healthcare, and in particular, mental health support. Number 3, Article 12, crossover children must be provided with the opportunity to be heard and for their views to be given due weight and consideration. We look forward to working with the committee and state parties on this very important issue. Thank you for your time.